As the saying goes, perception of reality can be so strong that it becomes more real than reality itself. And illusion can be so real that it becomes stronger than reality itself, regardless of whether it's in a, you know, a court case or otherwise. Oftentimes you realize that it's really an illusion. And most of the blockade most people face when it comes to things of this nature is based on just the illusion and the falsehood that they perceive. And these illusions and falsehoods can be detrimental based on your expectation. So it's always important to entertain the expectations of things, because your expectation can either create a reality so strong for you that it's detrimental to you because you have a false expectation, or your expectation can cause you to not see the truth of how things are. By virtue of that, it prevents you from being able to take the proper steps you need to take. One way or the other. The first thing most people need to really understand when it comes to things of this nature is your spirit game has to be strong. Whatever you do, whatever you put on a piece of paper, whatever you do, whatever you say, whatever you think, it has to be preceded by something that that the other party cannot quite observe of five senses, but will nonetheless contribute to the total outcome, to the totality of the circumstance of what's going on. If you are not acclimated to using black candles, rotten nails, you think it's awkward going ass naked at 1 o'clock, 2 o'clock in the morning, if you think it's awkward or weird to take plant intelligence and animal intelligence and mixing it together to get certain things done, then doing things of this nature would just either be just a hobby for you, somewhat of an intellectual jack off, or it would just be a form of torture for you. When doing things of these natures, whatever spiritual system you have, whatever modern version of religion you practice, or however ancient it is, there's always some spiritual solution to it therein your religion, or whatever spirituality you practice. Put those to use. And always allow that to lead first. Because that will be the template upon which everything you do sits on. If you've yet to get into the aspect of using your mind to move things, and then using other aspects the divine creator has created to assist you in getting that intent satisfied, then you probably need to get on it now. Because the people on the other end wearing those suit and tie, the people on the other end wearing those robes, the people on the other end, whether you and I choose to believe it or not, or whether they themselves even realize it, there are certain spiritual aspects that is assisting them do and accomplish what they are doing. That thing is neither good or bad. That thing does not care about how you feel, what you look like, what you think you are, or how you approach things. It simply functions based on an intent that it's been programmed to function. And everybody who comes under its auspice, everybody who works under it, does not necessarily have to know that it exists for it to do what it does. What you feel when you deal with entities and municipal entities, corporate entities, and when you deal with things with court cases, child protective services, criminal cases, civil, all these things, that subtle fear that you feel, there's more to it than just the false perspective that you've been fed that somebody has power over you. There's something that you don't quite see that is at work. Just like you and I are here on this earth, we have certain goals, certain activities that we engage in. There are other things in other realms that has goals and engage in consistent activities just as much as you do. But it correlates to what you do here. There are other entities that have interest in the outcome of what goes on in the reality that you and I perceive and observe. So always allow spirituality to lead first. And be honest with yourself. Straightforward with yourself. If you don't know about how planetary hours, planetary days corresponds to certain activities, and how certain planets corresponds to certain plants, and how those plants can be used for certain things, and whatever words or incantation goes with those plants and those activities, begin to learn it, because it will favor you. But nonetheless, besides that, certain expectations you should have so you get a better understanding of what this thing really is about is that any paper that you send into the the judge or the judge's chamber, that acting judge himself or herself doesn't necessarily touch it. He or she has attorneys that work under him or her. And all the papers you're sending in, before that judge touches it, it passes through the hands of attorneys first, and attorneys read it. If your paper is severe enough and carries enough weight, then it goes into the hand of the judge. Otherwise, peons deal with it. So don't think just because you've addressed a piece of paper to a judge, don't think that means he or she automatically reads it. Another expectation is that they will deny truth and fact, and they have the right to do so. Denial is a form of defense within pleadings. For instance, interrogatories. Even if they have signed the return receipt and you have evidence of it, the burden of proof is on you, not them, to put those receipts into evidence and show this man or woman has received this interrogatories during this day, and then they have this specific period of time to respond to it. If that is not on the record, they will look you right in the eyes and tell you, no, we have not received it. His interrogatory is one of those things that puts them in a situation whereby if they do, they're damned. If they don't, they're damned. Why would they want to admit guilt that way? It makes sense that they say, no, we haven't gotten it. And that's just an example of denial of truth. They will deny the truth and facts right in front of you. So don't expect them to be truthful or factual. Usually the plaintiff has heavier burden of proof, but even if you're a defendant, you are still treated as though you have heavier burden of proof. So always be on top of everything. And do not expect truth or fact to be spoken by them, whether it's through police report, through court orders, through whatever other papers they put in, or whatever they look at you in the eyes and tell you about. Your expectation is not to get involved in he said, she said. That is the realm that they love to function in. And that is exactly why they argue. And by they, I'm referring to attorneys. Arguments is the only thing that attorneys are trained to do. Let the material facts speak for you, and you simply make reference to it. Another expectation that you should always have is that whatever proceedings that you're going into, you should always expect to turn that venue into yours. If you're not planning to do that, then you will be ran over. Another expectation, that thing they call slavery, it is true and very well active. I-bonds and certificates and all things like that, the bonds, the D-bonds, the I-bonds people sign, all that is synonymous to the certificates that signed back when they used to sell slaves on podiums, where they would stand in public places and hold up a certificate and say, hey, I'm willing to sell this slave for this amount. Just sign it and it's going to be yours. Same thing happens. The only difference is now you're voluntarily doing it. And the people buying and selling you, who have interest in you, are called the bondsmen. And then there are other people that the bondsmen sharecrop that interest with in the back end that you don't even hear or see about. The bondsman is just getting the chicken change that you're paying him monthly. He's merely investing in the bond. And you being the surety, you're just paying the bond amount that he's investing in. There are some people that he's paying, and those are the real slave owners that have interest in that I-bond, D-bond, whatever it is that you've signed. But some of them are the judges too, and the clerks, the aldermen, the mayors, and sometimes the everyday man and woman who have sufficient amount to invest in those bonds. Slavery is very real. Another expectation is you're not expected to be intelligent. Yep, you heard that right. You are not expected to be intelligent. By the common people, the everyday man and woman does not expect you to be intelligent. When they hear you speak about certain things, when you engage in certain actions, they will look at you like you're an alien. They will even go as far as to look at you and say, you think you're smart, but you're dumb. You don't know what you're talking about. Yeah, at the end of the day, you know, if the tortfeasor is the one approaching you that way, if you know what you're doing, you might end up attaching their property, walk away and smile. They might get what they want, the instant gratification of, you know, just infringing on you because, you know, it's a form of power for them. So they just get that. It's like jacking off to them. They get that immediate release. You know what you're doing, and maybe 6 months, a year, if you don't allow it to drag out too long, they will lose more. But if you don't know what you're doing, then oh well. But for the most part, when you do things of this nature, you're not expected to be intelligent. It sounds kind of weird, and this is not to discourage you, but this is just an expectation of how people see the world. Another expectation is, if you're a defendant, do not delay anything. Yes, attorneys love filing things last minute. If the judge puts in an order that's saying, all right, plaintiff, you file your whatever, documents on the 1st, and by the 30th of the month, the defendant attorneys is supposed to file a response. Those attorneys will file their response on day 30. Because usually even after they respond, you still have the opportunity to respond to their response or put in an opposition or rebuttal, whatever it is. So it would not benefit them to respond on the 15th, the 10th, or the 5th just so you can rebut their response. No, they're not going to do that. They're going to respond on the last day. You, though, if you were the defendant or plaintiff, unless you really know you got the case in a bag, then don't do that. Always be prompt and swift with everything you do. Even if you have to go as far as to physically mail it so you get evidence and tracking that, hey, this other party has received it. Take that, put it as part of your exhibits, and add that to your certificate of service, and take those same exact documents that they received in the mail, and then get a file stamp copy of it. Because even if you request for a file stamp copy through the mail, it might take up to 2-3 months for them to get it back to you. Another expectation: learn the art of not being too long-winded. Whether you're a defendant or so-called plaintiff, always be swift with your words. Let your words be your sword. Another expectation: you will come across acting judges who are very, very comfortable. They will be so comfortable that they would want to tell you, hey, I'm asking you a question, just say yes or no. That's all that's required, yes or no. First of all, if a judge begins to approach you like that, they're telling you to give them yes or no response, you can never defend yourself properly, and you can never be afforded due process. Your right to your speech, and your right to petition, and your right to access the public record is just limited to yes or no. Secondly, bring the fact up that judge needs to stop speaking to you like that, because his or her job is to be neutral. And if he or she really intends to be neutral in the matter, then your response, your constitutionally secured right, should not be limited to a yes or no. You make that determination as to whether you want to respond yes or no. If they're leading you, that's a type of objection too, but there's no need to complicate. They call it objection leading, meaning you lead someone to respond a certain way based on what you say or ask. But you don't even need to go through all that. Just address that and nip that in the butt right from the instant. Another expectation is the way you perceive that acting judge. That man or woman up there wearing that black robe is not special. If they speak to you crazy right from the start, I guarantee you they will continue it. If you notice the slightest level of craziness coming from them, address that and get that straight. You don't have to be rude, but let your spirit pierce through your words. No matter how calm, how low your voice is, or how loud you choose to be. Make it known that this thing going on here, as far as you're concerned, is going to be constitutional. Another expectation: Don't let anything slip past you, because if you do, they will ride it all the way to the end. That's just not what the acting judge, that's for the opposing party. If you want to bring up that an attorney has no standing or capacity for whatever reason you want to bring it up at a very early stage. If you have any defense to bring it up at an early stage. Unless you didn't notice it, then you can bring that fact up when you bring it up later. Another expectation is know that you are in fact in a battle. The moment you get into any of these proceedings, it's a battle. And you must think and reflect on everything equivalently. And most battle must be won as quick as possible. You don't want to do a battle of endurance, although if that opportunity presents itself, then that endurance battle is an opportunity. Take it. Go at it. For the most part, most battles should be won very swift and very quick. Have that expectation in mind and set that intent. Another expectation: never under any circumstance presume that any acting judge, whether they speak politely or otherwise, whatever they look like, whether they look like you or not, do not presume that they will act honorably. Because it is not the responsibility of the government to prevent themselves from falling into error. It is your responsibility. If you're saying you are one of the people and you really have the power to do this and that, Constitution this and that, then it is your great responsibility to put them in check. Always. Don't get the positions twisted. And when you do put them in check, don't just do it just for the sake of letting an anger out. Don't just do it for the sake of just saying it just to feel good. Do it because you really mean it. And as mentioned earlier, when you let spiritual things precede you, all these acting judges, municipal police, all these people, you know how you do discovery in a case as to the fact of why and how you're being brought into a court, or how a defendant can do the same thing with you if you bring him in. You can do the same thing spiritually with people's spirit. You can do a spiritual discovery and weigh people's spiritual capacity. And you'll be surprised. Most of these judges out here and all these other actors in their capacities, they are spiritually lightweight. Especially considering the things that they do to people. That gives enough spiritual probable cause for whatever weight they have in the spiritual realm that's protecting them, for that to be waived. Another expectation: use the record to your benefit. And the way you use the record to your benefit is, even if someone is suing you, like if they write you a ticket, whenever they write you a traffic ticket, they're suing you. Or whenever it's obvious to you that you're being sued, lispendence or aggravated assault, failure to identify, whatever it is, trespass, whatever it is they're bringing against you, always approach it as though you're a plaintiff. Offense is the best defense. And through that, always create a trail and plant seeds as though you are setting up to actually sue them, rather than just merely fending up some claim. Otherwise, if you're busy defending, you will forever keep defending. Another expectation: pay very close attention to your verbiage. For instance, the word unlawful. Change the word within your lexicon. Change the word unlawful to unconstitutional, because in their ears and with the way they operate, law to them is their administrative proceedings. Law to them does not always constitute the Constitution unless you bring it up. To them, law is their little general rules and of court proceedings. Because every court has their own general rules besides the civic procedures. Law to them is their codes and statute, even though codes and statutes state clearly that it's a code and a statute and an act. Law to them is ordinance. So when you say this is unlawful or that is unlawful, they misconstrue that as, well, it's our statute, our ordinance, so we can do whatever we want with it, and you are deemed to be our subject. So you have no right to challenge it. Because if you're someone's subject, then a master is not deemed to be bound by what his subject or his slave says. So be more specific. Don't leave any grounds for presumptions. Say it as it is. If something is unconstitutional, say that it is unconstitutional. Another expectation is fear. Fear is normal. Do not try to run away from it. Your hands will shake, your palms will get sweaty. Your heart rate will increase. It's normal. Learn to understand it. Go to the root of why you feel that way. And the more you pay attention to it and nurture that fear, the stronger you'll get. And the more you actually be able to use that fear as a weapon to direct at others. Because obviously someone is using it against you. That's the only reason why you're feeling fear. And as weak as this may sound, the best way to deal with fear, circumstances where you have to speak up and stand up for yourself, is to nurture that fear. Interpret that based on your level of understanding. But whatever it is, do not ignore or try to abandon fear, because it's not going to go away just because you're trying to act like it's not there. Accept it and then deal with it. Another expectation is, know that they run through hundreds of people every day, and you are merely considered just one of them. So you must remove that presumption by making you their liability. Whenever someone is brave enough to sue you, make yourself their liability. Another expectation. The things that you do must be backed by wisdom and knowledge. Having passion and zeal is good, but the quickest way to damnation is to be passionate and zealous without knowledge and wisdom. And knowledge and wisdom is something that you would never completely learn. For that matter, it is always important for you to always seek after it. Good to be passionate. It's good to have zeal. But allow wisdom and knowledge to be the compass that guides that zeal and passion. Another expectation. Know that they hate the Constitution. They hate the Constitution with so much passion that they don't even want to hear that word Constitution. Because that is the only thing that really holds them liable when it comes to pen and paper. Another expectations. You probably shouldn't care about someone's personal feelings. If you intend to speak and stand up and you're caring about how someone feels about you or what you say, then you probably should reevaluate your values. Because your personal feelings and emotions is an irrelevant factor to what they do. And it should be the same thing on your end. Another expectation. They will come at you from different angles. They will attack you from different ends. They will use more than two-pronged attacks. They will use probation, criminal history. They will call family members, whether you have warrants or not. And know that in them using different forms of attack to get what they want from you, they have database of information and they will use that against you. And that goes beyond your criminal history. Learn how technology works, and it will always favor you. Another expectation. One of their main powerful tools is something called induced liability or induced conversation through accusation and through recontract. They induce you to take liability by engaging in certain types of conversations, which is accusatory in nature. And that automatically puts people in defense. Pay attention to that. 8 out of 10 times when they talk to you, that is exactly the angle that they will come from. And even when you do something right by your words or what you put on paper, they will recontract with you. And all it takes is you're on probation and you somehow manage to ward that off because you realize, oh crap, this is a contract. So you got rid of it. All they have to do is have that probation officer call you and put you under duress and just say, hey, can you just meet up with me at 2 o'clock? And you go up and meet and you're thinking, oh, well, we're just going to talk about what's going on. And before you know it, you realize that when you met up with that probation officer, you should put that down as a status check of your admission of guilt to the probation. So now you just recontracted without even realizing it. And even if you put all this good stuff on a piece of paper when you begin to talk during the hearing, they can easily recontract with you by asking simple questions or just by going along with what they're doing and you just casually playing along by getting stuck in a role of defendant rather than you sticking it to them. Another expectation. Never expect them to just bow down to you just because you speak up, just because you say you are this or that. Remember, they've been doing this for years after years and are living a very good life from doing it. Monetarily, at least. Most of these people are really not emotionally stable or happy, and most of their personal relationships are really not that stable. And they really have no work-life balance. But when it comes to the monetary aspect of it and the satisfaction of feeling like they have some type of power in society, they need the job that they do to feel like that, to get that. It's like a form of addiction with sugar, with tobacco. You can have work and job addiction. Most of these people do have it. So if you go in there with the expectation that just because you say this or say that they're just going to bow down to you, you're setting the wrong expectation for yourself. Be realistic. And don't half-ass what you do. Because if you half-ass it, you're not really going to get the desired result. So whatever nationality you think you are, whatever ethnicity you claim or presume that you are, you just saying you're one thing is not just going to automatically cause everything to halt. What you say you are is based on your ability to enforce what it really is, rather than merely just saying that you are that thing. You have to know the laws that govern you and others around you in society. Another expectation is you will be put under duress. Because duress is just a tool and tactic of war. And these people have that mindset. And it's just normal mode of operation for them to use it. Whether or not you allow it to be effective is up to you. Another expectation is you must comprehend and really be savvy to the principles of capacity and standing. Because if you really wrap your mind around that and really get it, that alone should be enough for you to really crumble everything that they have placed in front of you. Another expectation. An attorney's job, if they want to represent you, is going to be exactly this. They're going to tell the judge how much money you make, that you have a fine personality, that you have a good character, that you graduated high school, that you have 6 children, that you are currently working on this amount, that you take benefits, that you're a veteran, and that you're a hard-working man or a hard-working woman. They're not going to say, hey, this guy did not do this. Or at least 7 out of 10 times. They're not going to do that. But they will definitely hand you to the courts by just stating things that basically establishes self-confession about what you are and how much money can be made off of you, and how much of a victim you could possibly be, and how easy it is for them to get away with it if they were to go at you. That's all an attorney is going to do. But there are some pretty good attorneys out there. I know a lot of people speak bad about attorneys, but there are some pretty good attorneys out there. And this is how you test them out. If an attorney insists on being your public defender or insists on representing you, fine. Not a problem. That's cool. Rights and obligation of contract and rights of association exists. You want to engage in a contract with me by speaking on my behalf? You want to act as my daddy or my mommy? Cool. Not a problem. Under this very simple condition, put it on paper. It should only be about 1 paragraph or 2 paragraphs. It should not even be up to half a page. So let him know if you choose to represent me, make sure that you enforce the rights within the Bill of Rights. Then create the contract of what you want them to do. You want them to dismiss this case within this specific period of time, based on prompt hearing, as affirmed by the Constitution, and that your affirmative defense must be made strictly with the Constitution. If not, then they can just voluntarily terminate themselves, and then just have them sign it. Then put a liability clause in there that if they don't, that they owe you specific amounts. That simple. If someone really cares about you so much that they just want to help you defend a case so bad, fine, sure, do it. Here, just sign your life away. Just go ahead, put your hands in it, sign it. If not, then you and we don't have anything together. If an attorney does not choose to exercise his constitutionally secured right, and they are planning to speak on your behalf, and if you put a clause in there that says that you retain the right to speak for yourself, even if you retain them as a counsel, if they don't agree to that, then that's a telltale sign that that attorney really has it. He or she does not have your best interest in heart. Take it a step forward. Even if they don't sign that, and you know that they love just playing the game of slavery, meaning they'll just go ahead and make that ex parte decision and just throw an officer of the court on you. Nonetheless, lead them to the step, terminate them, put it on paper, put it in the form of a notice. Use the maximum of law and equity. Use the Constitution. If you don't know the maximum of law and equity, use the Constitution. Right of association, right to choose your own counsel, right to due process, right to freely speak. Invoke those and tell them that you don't intend to enter into such contract with them, expressed or implied. And if they impose themselves on you, it's a self-admission to whatever contract you want to create within that same notice. Whatever reasonable punishment you want to enforce, put it in there. The reason why you're doing it is because of trespassing your constitutionally secured right. If they want to be the guy on the other end towards that, good. Let them volunteer for it. They love being volunteers to cases. Let them volunteer into that termination contract. So personally, I love attorneys. If they can get into contract with you, sweet, perfect. If not, and believe it or not, all that suit and tie, all that charisma, because some lawyers actually, some attorneys and lawyers actually have some pretty cool charisma. And if you study their personality and character, you can actually learn from them. You really can. But all that cute charisma and all that stuff, you'll get to a point where, at least you should get to a point where you eat it. That should be like honey and food for you. The more you see that, the more life it should give you, because that's food right there for you. And you'll begin to realize very quick that most attorneys, especially if you got your spirit game right, most attorneys are flimsy. Very flimsy. So I like attorneys personally. Draft up a contract and present it to them. If they don't want to enter into it, well, present another one that says, well, since you don't want to enter into a contract with me and you want to impose yourself upon me contrary to the Constitution, then, well, this is your penalties. Just by your mere act of engaging and adjudicating this matter supposedly on my behalf without my consent. Sometimes it's really just that simple. But overall, if you take nothing away from this, spirit game should be very strong. You need that. all that African booty scratcher stuff people make fun of, if you've yet to get to it, I think now is the time for you to. All that mysticism stuff, I'm not talking about pseudo spirituality of doing stuff just because it's trending or just because it feels good. That's the quickest way for you to get your ass kicked. Don't do that. Really get into it because you're serious about your life. Put it to use. Sometimes you'll be surprised how powerful you are. Way more powerful than your pastor, any babalawo, any priest, any master mason, any of those. You are spiritually potent than most of these people. And all you have to put into it is just your mind. Care enough about your life. And when you care enough, all these plant spirits and animal intelligence, when you call upon them, they will respond. They will work for you. These people on the opposing end, these judges, lawyers, they use these things. Why aren't you using it? Because in their Masonic halls, once they get to certain degrees, they learn about these things. But you can learn about it for free. You have the whole world in your hand. It's called the internet. Put it to use.